Thank you very much for having me, and thank you, Roger, for inviting me. Roger and I do go way back now. I met Roger in 1992, and he told me that he would like to take a year off of his graduate studies to come read Hegel together. And I'd adopted a little baby who was, and so that's also got Roger some serious skill in parenting. But we read the entire Hegel's Greater Logic together in German. Roger is a much better Germanist than I am. And we went on to read Heidegger in German, Kant in German. We always referred to it as our group, as our reading group. There was in fact the two of us. And we were a very exciting part in the Critique of Pure Reason, which Roger was translated when his wife went into labor. And I gave Roger, I think, the very good advice that it was perhaps time to cut our Kant reading group short, or he was going to be in much bigger trouble than I could imagine. So it's a great pleasure to, and that is a true story. We were really in a very exciting part of the Critique of Pure Reason when Madeline decided she was going to join us. So thank you very much. It's always a pleasure to be involved. I want to just give you a kind of an overview of some of the central concepts of the South African Constitution, because it's a very different kind of constitutional schema. And I want to start out by introducing you to the idea of a substantive revolution. The word substantive revolution had now become part of the jurisprudence of South Africa, because it was an attempt to define what the constitutional project was as it's related to the long struggle to overthrow apartheid. Many people, as you know, refer to South Africa as a miracle. It was not a miracle. It was a 25-year bloody civil war inside the country and on the border of Angola. Hundreds of thousands were killed, hundreds of thousands were imprisoned, hundreds of thousands were tortured. And it's certainly not in any sense to pay heed to what they gave to say that this was some kind of miracle transition when the National Party voted themselves out of power in a referendum, which they did do in 1992. And that's when the negotiations began. But this is after 4 years of a movement called the United Democratic Front, basically shutting the entire country down. The armed struggle continued, and there were, of course, movements after waves of movements, the Soweto Uprising in 1976, Black consciousness in the late 70s and early 80s, and then the United Democratic Front, which ran the most successful international boycott, coordinated with internal strikes and school shutdowns. And so, in fact, it was the people who made South Africa ungovernable. So in that way, was it a revolution? I think the answer is clearly yes, but here's the difference. It wasn't what the theorist Hans Kelsen calls a full procedural revolution, which leads, I think, to some of this use of the word miracle. A full procedural revolution, for those of you who aren't in my generation, is when Fidel and Che marched into Havana with flags and said, everyone's fired, all the laws are wiped out the books, and tomorrow we begin a new day and we start from scratch. That's not what happened in South Africa. So substantive revolution has two prongs. The first is that it's a legal transition to power. Now, Hans Kelsen was once asked, did he think such a revolution is possible? He said he wasn't sure. Because in this case, the National Party did in 1992 in a referendum. Blacks did not have the right to vote, voted themselves out of power and into negotiations, which meant really from 92 to 94, when Mandela's elected, that there is no functioning government. Again, there was an incredible violence between different political groups. There was no functioning police, there was no functioning army. And all during this time, the constitutional negotiations are going on. However, it's seen as a legal transition, as the National Party voted itself out of power and voted itself into negotiations. That's prong one. And with that prong one is that all the judges were fired and all the laws weren't wiped off the books. We're now going to see what this means for the constitutional dispensation. But the other word is substantive. And in the jurisprudence and in the Bill of Rights, I'm going to get my Constitution out for you in a minute. The idea here is that there had to be a complete substantive ethical change that overthrew all aspects of life associated with apartheid. And that project was embodied in the Constitution as what Emeritus Justice Laurie Ackerman has called a moral constitutional categorical imperative. And so the Bill of Rights are based on the idea that everything must be transformed in the country towards dignity, equality, and freedom. And that is then the foundation or the grundnorm for the entire Constitution. And it is a moral as well as a legal mandate. And this way it's much more resonant of what Hegel would have called the German philosopher a Rechtsstaat, rather than an idea that law and morality are separate. And this leads to the phrase, which oftentimes gets used in South Africa, transformative constitutionalism. The purpose of the Constitution is to transform the society in accordance with those regulative ideals. And we'll see just how Kantian, at least one, following Immanuel Kant, one of the judges certainly is. So if you don't wipe all the books clean and say, okay, all the old laws have obviously been contaminated by apartheid, what do you do? Particularly if you're now reading the entire document as a substantive revolution demanding complete transformation of all the ethical relations between human beings on a day-to-day level. The answer is that every single judgment that comes before any court, there's magistrate courts, high court, the Supreme Court, which is not their constitutional court, and the Constitutional Court, must, in that judgment, show that the law that is before them and is being contested in one way or another in adjudication is consistent with the Constitution. There's a famous judgment by Justice Ackerman and Justice Goldstone when they were on the court that said that that means you have to say why this particular contested law is constitutional. You can't assume it, because if you assume it, then you're not doing the transformative work, because so many areas of the private law, there's two other sorts. The Constitution is the ultimate and only enforceable law, but there's other sources of law, the living customary law, the Roman Dutch law. And you always have to say, are these regulations or laws or statutes, whatever you're dealing with, consistent with the Constitution on the face of the document? And in Carmichael, the judge did not take account of why the particular law at stake was consistent with the Constitution. So I just want to read Justice Ackerman on why this is so crucial to the substantive revolution. Our Constitution is not merely a formal document regulating public power, which is very much the reigning definition of the Constitution in the Anglo-American world. It also embodies, like the German Constitution, an objective normative value system. The influence of fundamental constitutional values on the common law is mandated by Section 39(2) of the Constitution. It's within the matrix of this objective normative value system that the common law must be developed. This requires not only a proper appreciation of the Constitution and its objective normative value system, but also a proper understanding of the common law. We previously cautioned against overzealous judicial reform. The proper development of the common law under Section 39(2) requires close interaction with the Court of Appeals to have particular expertise and experience in the area of law and in the land. However, all of the laws of our country must now aspire to meet the great ideals embodied in our Constitution, and therefore in each judgment the judge must speak to how or why this law is consistent with those ideals. Now, this is a very different way of thinking about constitutional interpretation, because it is both an interpretive clause and it's a moral mandate. You must speak to why this law is consistent with transformation, and this takes the place then of the wiping the laws off the book. If there's a law that has to be found to be inconsistent, it can be developed, it can be struck down, it can be sent back to the Parliament. There's many things you can do. but you must never allow any law to remain on the book that is not consistent with the ethical transformation that's mandated. Now, dignity in South Africa then, particularly for emeritus justice Ackerman, but for almost all the judges, is considered the grundorm of the entire Constitution. And for those of you who know something about Anglo-American law, H.L.A. Hart, for instance, the rule of recognition was that which divided up different parts of the government and was the rule which said, you know, the courts do this, the legislature does this. But this is not that kind of grundorm. The grundorm is the moral, constitutional, categorical imperative that mandates that the entire country be shifted towards dignity, freedom, and equality. In this sense, it is explicitly a regulative ideal, and indeed the longest discussion of Immanuel Kant in constitutional jurisprudence is done by Emeritus Justice Ackerman, where he says the entire project of South Africa is to harmonize together our ends in the kingdom of ends, and only if we are doing that on a day-to-day ethical basis are we going to actually be able to transform and make the Constitution work with the paper it's written on. And this becomes very crucial to the definition of freedom, which is explicitly Kantian. Because the idea in Kant is that freedom is not lack of restraint. That would make absolute no sense at all for Kant, because we're a phenomenal creature, we're part of the laws of nature. We all want to put ourselves on moral holidays all the time, not just the people in South Africa, but all of us. And we have a possibility that we might be able to lay a law unto ourselves, and that's the categorical imperative. And when we lay that law unto ourselves, then we are acting in accordance with freedom. This is what is called the reciprocity hypothesis in Kant, which is that freedom and morality are the same. They're opposite coins, but they're interconnected and absolutely intertwined. So in a deep sense, freedom is a form of obligation and is self-limiting in that way. It's self-limiting both because it's tied to individual obligation, and this is a part of Kant that oftentimes doesn't get understood, but it's very much part of the jurisprudence of South Africa. It's self-limiting because when I do the next right thing, I do it to you or to someone else. And therefore the mandate on me is always collective. It's to harmonize my ends in the kingdom of ends with your ends. And Kant uses the word harmonize. It's not just about us finding a way of you have your interests, I have my interests, and we try to risk manage it. We actually try to harmonize those ends. Therefore, this becomes the basis then for a very different idea of what it means to be free. Now, for instance, can you be free and be a racist? The answer for the justices is no. Because when you're a racist, you're tied up in the phenomenal world. You're tied the idea that you're better because of a certain skin color. And this led to some of the most radical provisions of the South African Constitution, which come in Section 8, which we'll get to in a moment, the horizontal application of the Constitution. And you be a sexist and be free? The answer is no, because when you're a sexist, again, you're completely caught up in the phenomenal world. You're unable to exercise your autonomy. Autonomy is not self-determination. That's an Anglo-American misunderstanding of it. So the last thing we can do is be self-determining as a phenomenal creature. That's why autonomy has to be law-like. It has to be a law that we lay unto ourselves. The big philosophical question in the jurisprudence of South Africa is actually what is the connection between the realm of internal right and the realm of external right. And in a certain way, this jurisprudence, perhaps beyond what Kant himself ever would have been comfortable with, says the realm of internal freedom and the realm of external freedom, what we see as embodied right, have to be connected to one another absolutely if there is going to be the kind of transformation, the thoroughgoing transformation of a substantive revolution in South Africa. Anything else will falter and fall back into what has been called again and again the kind of racialized thinking that dominated the entire country under the apartheid. Now, Kant in a certain way then is also an egalitarian, but of a particular form, because we all have this capacity to lay down a law unto ourselves. And during the question and answer period, I'll talk a lot about Ubuntu, the other big value or ideal in South Africa. And so it's this form of horizontal thinking. Before the moral law and the possibility of us exercising our autonomy, we are all equal, and it's an equal possibility for each one of us every time we're confronted with the infinite, as you can imagine, moral and ethical demand of a society that's decolonizing itself. Now, most constitutions, as a limited form on government power, as they're conceptualized in a lot of legal theory in the Anglo-American world, would never take the next step that the South African Constitution did. The South African Constitution has direct horizontal application. So if you think that I violated your dignity, then you can sue me and take me to the Constitutional Court. There doesn't need to be state action. And this becomes particularly important as it leads to another concept, the objective normative order, which Justice Ackerman obviously hammers on. So that means that you're not limiting state power with the Constitution. You're embodying a moral, ethical ideal, which is to be enforced by each one of us. This also takes us to standing. In the United States, you have to have what you call a case or controversy to get standing. The citizen in South Africa can say, you know what, I was in the supermarket the other day and I was reading the newspaper and there was this law passed and I think it's thoroughly racist. And you can do what they call direct appeal to the Constitutional Court. And it's even seen as a mandate that you do that type of work, whether you're a lawyer or not, because this is the way in which the laws have to abide by the Constitution. So standing and horizontal application are completely different, rooted in this idea. But what we're doing in this Constitution is we are changing ourselves and changing each other in day-to-day relationships. This is the only Constitution in the world that has a direct horizontal application. The idea was that it was necessary to avoid privatizing apartheid. This is very delicate jurisprudence, and here is where Ackerman says you need to make the distinction between dignity as an ideal and dignity as a right. As in these competing right cases, you're going to look first to dignity as an ideal and perhaps then to dignity as a right. And that's going to be the value that ultimately will be the judicial principle that resolves the dispute. And Justice Ackerman has given a number of examples of how this comes up all the time. One of the obvious examples, since horizontal application was meant to not privatize apartheid, is the idea of privacy and right of association, which the South African Constitutional Court has and recognizes, but it also recognizes right to housing, right to education. Socio-economic rights are fully enforceable as any other forms of rights. This is all part of the objective normative order, and we'll come back to the meaning of that phrase in a minute. So, for example, one of the examples that Justice Ackerman has used, say you're a restaurant owner and you have a bridge club, and a young black woman comes into the restaurant and you're hanging out in back playing bridge with your 5 cronies, and she wants to join your bridge club. And she feels that her dignity has been assaulted because here she is, a very good bridge player. She always eats dinner in your restaurant on Tuesday. A restaurant is a public good, but that wouldn't even be what would make the case turn out to be one way or the other. So in direct horizontal application, you have to say whose dignity is an ideal is actually more infringed upon. The bridge owner who wants just to play with his cronies, or the black woman who wants to join the club and she feels that she's being violated in her dignity, if she can. Dignity is an ideal attribution of the person, not something you can lose, which is a big misunderstanding of dignity, but it is something that can be violated. So these kinds of difficult competing rights situations come up time and time and time again. In fact, Justice Ackerman and I disagree about this. I think the court would have to, if this was a real hypothetical, have to decide in favor of the black woman. He thinks they would have to decide in favor of the restaurant owner to be able to continue to play bridge. But the point that I'm making is that horizontal application is seen as being part of the substantive revolution, and the only way that you can think of citizens actually making the law their own as a kind of constitutional categorical imperative. Now, what is meant by an objective normative order? And this, again, becomes very important because it leads to something that we would barely be able to understand, I think, in the United States constitutional law, which is that apartheid was always wrong because it was a violation of dignity. Because dignity is read as an ideal. That means that the ideals and legal norms of the Constitution do not arise out of the practice of law. There is, in that sense, a moral order that was always there, rooted in dignity. And therefore, any violations of dignity that had taken place in the past, even if they were completely consistent with the positive law, were wrong. So this led to two very important decisions, which were called Sodomy I and Sodomy II. South Africa was the first to give gays and lesbians and the transgender the right to marry as a matter of dignity, as well as equality and freedom. But dignity was the primary justiciable principle. Again, both as an ideal and a right in that case. So an objective normative order is one that pre-exists the positive law and is rooted in dignity. Now, what this meant for the sodomy cases, in South Africa, sodomy was a crime. Now, for those of you who are women in this room, you'd be pleased to know that we were never counted as having serious sex. So it didn't involve lesbians, because two gals fiddling around isn't sex. In order to have sex and have a state involved and have to regulate it, you have to have two, you know what's, doom. But many gay men went to prison over this. And were going to prison for a long time under apartheid. Meanwhile, we could fiddle around freely, so I guess there were some advantages to being a girl under apartheid. When Justice Ackerman decided Sodomy I and Sodomy II, he said that not only was it wrong now, given the Dignity Clause, it had always been wrong. And that meant the state owed reparations for violating the dignity of those who had been put in prison. Because if you had been acting in accordance with dignity as a moral right, you would have known it was wrong, as you would have known apartheid was wrong. So in this way, Ackerman says, you do not interpret a law to be invalid, you declare it to be invalid, which is a completely different way of thinking about invalidity. To quote Justice Ackerman again, the court does not invalidate the law. It merely declares it to be invalid. It is very seldom patent, and in most cases it's disputed that pre-constitutional laws are inconsistent with the provisions of the Constitution. It's one of the court's functions to determine and pronounce on the invalidity of laws, including laws of Parliament. But this does not detract from the reality that pre-existing laws either remain valid or become invalid upon the provisions of the Constitution coming into operation. In a deeper sense, however, these laws that were there and violated dignity were always wrong. And therefore, when the court acts to recognize that wrong, they're simply declaring the wrong that should have been noted prior to that. But very simply put, we have the idea, right, if it's legal until it's declared illegal. That's exactly what they don't have in South Africa. And that's the significance of talking about an objective normative order. We oftentimes now in our common law think of a legal order as just what the disputants actually win. So until there's adjudication over a particular law or statute, there's no law that exists or doesn't exist. So the subjective clash of adjudicatory wills brings in the common law that moves through the objective clash of adjudicatory wills. Here you have something very different. What's being adjudicated is the deep basis of an objective normative order that should always have been intact if we were to be living up to the mandate of the categorical imperative. Is there a separation of law and morality in South Africa? The answer is no. Is there an attempt to create a new creative, what Hegel would have called Sichtlichkeit, a new South Africa and a new South African out of the ashes of the old? The answer is yes. And the Constitutional Court has a particular role in that function, which is it is to hold the mantle place of the ideals to which the country is aspiring. This, again, is a very different view of the Constitutional Court. And part of that is historical, because the way laws were passed in South Africa is whatever the parliament said went, and there was very little judicial review. In the course of negotiations, and constitutional negotiation, they decided they needed a body that would hold on to the mantle of ideals, and that body would not be one that was directly elected. It's appointed by the president and then voted in by a special commission of the judiciary. But they do not have lifetime appointments. You're appointed to be a judge in South Africa for 15 years, long enough to shape your legacy, and then you step down. What makes South Africa and the substantive revolution important, then, I think, are three things. The first is, in a world in which ethics and morality seem to be tired phrases, often, of hopeless idealists who don't know how to risk manage and get ahead, the South African Constitutional Court has made the dignity of all others an ethical and moral basis that is there in its deep sense in eternity and should have been noted as such. And therefore, the call for all South Africans is to live up to that constitutional categorical imperative. The court can't do it alone. It can outlaw sodomy, it can recognize gay and lesbian marriage, it can outlaw the death penalty. But as all the judges say over and over again, there's no final constitution. It's up to every South African to live by the moral mandates of the substantive revolution. The second is that law and revolution became decoupled in the 20th century. We know that took place in part because of the conditions in which the Soviet Union was established. However, even then, at the time that Lenin was making many of his decrees against a constitutional state, Rosa Luxemburg was saying, no, constitutionalism and Marxism must be and always stay wedded. But indeed, they did not. And they came apart, and Hannah Arendt, amongst others, since we are speaking Hannah Arendt Center, speaks about the difference between different revolutions as to the significance of that uncoupling. But by the time of the Third International, the idea of a substantive revolution was simply seen as an impossibility. It was a full procedural revolution, or it wasn't a revolution. Then the third aspect of this is that it makes us think differently about success or failure of revolutions. One of my least favorite people in the world, Professor Dershowitz, just declared yesterday that South Africa was a failed state. And the last time Professor Dershowitz and I debated one another is when he was defending torture as completely consistent with human dignity. And I never really saw torture as consistent with human dignity, but he has creative, interesting arguments. What this complicated notion of a revolution does is it makes it very difficult to say that the revolutions absolutely failed. Now, I'm with the great economist, South African economist, Zambi Terenblanche, that the transition is either incomplete because of its failure to engage in full sweeping economic reform it needed to do, and the African National Congress had promised. And so that transition is either incomplete or staggering. But what you see, of course, is mass movements arising all over the country. The country's in a general strike today, led by the gold miners, which have now become a political movement, and tied to the economic freedom fighters. And so the question of what it means to fail or succeed, since so many, as you know, we say, oh, socialism's over, it failed. Well, the question of success or failure of this kind of moral, ethical transformation is way too complicated to yield to that judgment. And so that in a deep sense, you have a different, more rich idea of what revolution is, and with it, the demanding hope that we can bring it about. Because what is the goal of, from each according to her ability, to each according to her needs? Wasn't it to realize a world in which the dignity of all others was not just an empty, hypocritical quote, but actually meant something? And so I think this is what has made the transformative constitutional project in South Africa not only relevant for South Africa, but relevant for rethinking ethics, law, and revolution in the 21st century. Thank you.
guys talk to Drucilla, who I'm sure you want to talk to because you get to talk to us all the time. I want to first just say something about what at the very end of what Drucilla said, this idea of hope and constitutional structure. And one of the things that we've talked a lot about over the years is the difference between the constitutional systems in the United States and South Africa. And one thing that is often said is that the United States Constitution is not a substantive constitution in the sense that Drucilla has talked about it, that it's a written constitution designed to limit powers. It's seen often as a limiting. We often read the Constitution today through the Bill of Rights, which we often forget was not in the original Constitution. And we think of that as the most important part. And when you go to law school, everyone wants to study the Bill of Rights and First Amendment and all those 10 amendments. But there's another tradition of American constitutionalism, which is a substantive idea of American constitutionalism, which is that it's based in a principle of self-government and representative government. And there is a tradition, therefore, of a substantive idea of American constitutionalism, one that's largely been lost, I would suggest, in the 20th and now 21st centuries. And we've talked about this, we just talked about it on the radio a little earlier. There is a project to be had, to think of a hopeful project of thinking about the United States as a constitutional state that would return us to a substantive view of the Constitution around the idea of self-government. And there's a lot that might be contained in that. The second thing I want to say, and I want to keep it brief, is I had an essay in the same book that Drucilla edited on Dignity Jurisprudence, and one of the things that I think is important for us to think about, if we're going to, in South Africa, think about a substantive room norm for a dignity jurisprudence, is what is dignity? And and I think what Drucilla said in these examples that she gave, the black woman comes in and there's a white guy with his cadres in the back, and Laurie Ackerman, who's the justice who's most really responsible for dignity jurisprudence, says, no, the white people have a dignity right to hang out with whites. And that's a private right, and you can't, it would be impinging on their human dignity to force them to bring blacks into their group. Drucilla takes the other side, right, that no, the black woman has a dignity as a person who wants to play chess with another citizen of South Africa, and to exclude her because she's black is to, in a sense, to deny her dignity. I don't think there's a simple answer to these questions. And I think that it requires, that any kind of honesty requires us to understand that there's very difficult attempts to answer these questions. It's helpful to think about what dignity means. And in that regard, I just tell a 5-stage little story about the changing nature of dignity in history. The first real, I say the first that I know of entry of dignity into the Western political canon, and I'll be unforgivably Western in this regard, is in Plato. And in the Republic, Plato speaks of the word presbyia, by which he means virtuosity of age. And what he says is that the good is older than being. The good has more dignity than being. And this is, in many ways, the way that the word dignity came into the Roman language as a translation of presbyia as dignitas. And for the Romans, dignity, a dignitary, was someone who was old. We think of that today. We still, someone who's dignified, who's old, who has a certain gravitas to them. And there was a certain amount of idea that dignity had to do with wisdom and age, and the wisdom of age. The great inversion in the history of dignity comes with Christianity, for whom Christianity says that dignity applies equally to all humans who have a soul. It's an equality of the soul in Christianity. Whereas for the Romans and the Greek, dignity was of some people above others, and thus as a mark of distinction, and thus was not equal. It was high. It was the idea that it was something higher. For Christianity, our dignity is all and being in the image of God for human beings. The Kant is the next great attempt to rethink dignity, and he thinks it in a Christian way. We all have equal dignity, but it's an equal dignity not of being born in the image of God or made in the image of God, but of having reason. We are, he says, rational beings, vernünftige Lebewesen. And as rational beings and all having the capacity to reason, we all have a certain dignity in that we must be considered as ends and not as means. We can't be treated as means to some end. I would suggest that the next real important thinker about dignity is Hannah Arendt, who, as some of you know, because you're taking a class on this right now in dignity in the human rights tradition, comes to the conclusion in the 1940s and 50s that the whole Western tradition of dignity has failed, and that the Christian and the Kantian confidence that we can just assume that humans have a kind of dignity no longer can be honestly and empirically accepted in the world. And she says we need to, in a sense, create a new law of dignity on the earth, a new political idea of dignity as opposed to a philosophical idea of dignity. And she doesn't actually develop it in the book Origins of Totalitarianism. Where she does develop it is in her next book, The Human Condition, where she attempts to argue that the dignity of man is found in two of his characteristics. One, his characteristic of being a beginner, that as a beginner he can always act and act freely and start things new. And the second, in his givenness, and this goes to privacy, in that he is unique and different and has the right to be different from other people and to develop his uniqueness in private, which is where Laurie Ackerman, in a sense, would develop his argument for the white men hanging out together. And so Arendt attempts to argue that dignity has this double sense of, this is a strong reading of Arendt, but one I'm happy to defend. On the one hand, of a political reading where we together start things new in our freedom collectively, including our freedom to have a substantive revolution. And on the other hand, our givenness, and thus the need to protect our hiddenness and our privacy to be unique and different in who we are outside of a public sphere. And so I set this out in the book, and I set it out here simply as an attempt to begin the difficult work that I think has to go on in South Africa if we're going to argue that South Africa is a constitutional state with dignity as its true norm, in really doing the hard work of thinking what dignity is. And I'll leave it there.
Should I respond or not?
Unless you really need to, I'd say let Peter talk and then we'll open it up and we can all chat.
I guess I'm going to come from a very different angle and kind of think about the court as an adjudicator and where we situate maybe some of these ideas, or at least some of the concerns that one might have. And I have so many that come up to mind that I probably won't get to all of them, but some of them are just stories to tell. The concept of Grundnorm, and in the name of Hans Kelsen, in much of the developing world, symbolizes the ideological legitimation of changes that should never have been allowed. It's a hated concept. Whether you're in Ghana or you're in South America or you're elsewhere, it is remembered as having been used to legitimize illegitimate transitions that took place in those states. And I mention that not because it applies here specifically, but it makes me wonder more generally about what happens when large ideological, philosophical notions are incorporated into judicial thinking. And over time, as I've gotten older and watched courts, I've come to love the pragmatists, the ones who disdain or claim to be disdaining ideology, and have remained or become much more suspicious of those who embrace a philosophy and the fear that in embracing a philosophy, they're hiding their own ideologies. Roger mentions the substantive period in America. I mean, what I thought he was going to mention was the era of substantive due process in America, which is famously, again, the moment when the judges discovered substance in the due process clause, and it just happened to mean that the government couldn't intervene to regulate the economy, that it couldn't protect workers, that it couldn't intrude on the right of contract. Now, all of this to me is relevant in the context of South Africa because we've been celebrating South Africa avant la lettre, before there was ever something there to show for it. South African jurisprudence is in comparative law textbooks where countries like India or Argentina, countries that have done really beautiful, fascinating things with constitutional adjudication in the last years, although inconsistently and sometimes incoherently, aren't in those textbooks because the textbooks writers don't know how to fit them in, because there isn't a clarity, a systematic quality, or a translation that's available. So South Africa has been celebrated. Are we right to celebrate it? We're obviously right to celebrate it for the beauty of the Constitution that was drafted, the process of inclusion, the willingness to dare to approach issues of horizontal application, to look at dignity and to others. But now I want to tell another little story. In 1989, I was a student at Columbia Law School, and a man named Albie Sachs came to teach there. And Albie Sachs came, his arm had been blown off. He'd been in a hospital for months before that time. And he arrived having spent several years in Mozambique, where he had been part of a judicial reform effort, a judicial revolution. Albie arrived, it was amazing. I mean, we were all honored, admired here, this man who the apartheid state had tried to destroy, to kill. The first place he arrived afterwards was Columbia. We waited for him there as students, and he disarmed us with his humor and his warmth from the very first. And he went on to teach a course that celebrated popular justice and the revolution that had taken place in Mozambique, and described in theoretical and practical terms the amazing strides that had been made in Mozambique by applying notions of popular justice, new thinking about participation, transparency, openness, that were transforming norms that had been there before. So fast forward to the middle 1990s, I arrive at Harvard Law School, where I'm running the human rights program, and Albie Sachs, now a member of the Constitutional Court of South Africa, is come to Harvard to teach. And I keep coming back to Albie and saying, Albie, but what happened in Mozambique? What happened? And Albie doesn't want to talk about Mozambique. That was then, that was gone, it was finished, let's move on. We're in South Africa, we have this beautiful possibility. And finally, after I just pestered him in every public and private gathering, he finally said, he threw up his hands and he said, you know, it's as if the buildings in Mozambique had memories of their own. And as soon as the wave of this optimism, of Frelimo, of popular justice passed, they just returned to the old ways. What was different in South Africa? Well, again, in these kind of back and forth that I had with Albie, I kept pushing and saying, you know, what about Albie? Albie, I was just in South Africa. Everybody I spoke to in the Ministry of Justice in South Africa, when I asked them, why is there a truth commission? Why is there this? Why is there that? Instead of celebrating this wonderful thing, they're all saying, yeah, we didn't win the war. We had to compromise. We didn't get what we wanted. We had to compromise. And Albie's response eventually to that was a beautiful response. It was, he said, finally, thank God we didn't win the war. I saw in Mozambique what happens when they thought they won the war and there was no one to stop them. And maybe we can do it better because we didn't, because we have to compromise. And so I come back now to where the Constitution is. The Constitution is also a negotiated compromise in South Africa. It involves, at a huge level, compromises between group rights and individual rights. Choices that were made in order to hold on to an Afrikaner interest. Interpretations of human rights that are diametrically opposed. Human rights was a wonderful platform to bring people to the table in South Africa, but it meant different things for the whites than for the blacks, and still does. For a whole population, human rights means we get to keep what's ours. Due process, property clause, and for the majority of the population, it means we get some of what's yours. We get transformation. They're the compromises between group and individual rights in South Africa. They couldn't take group rights because of the National Party and the Afrikaners discredited the idea, kind of subjugated the thinking about customary law, played around with it a lot, brought in a women's commission because it was going to balance the other commission. But at the end of the day, what you have is you have a compromise and an uncomfortable one of negotiation in terms of what people's senses are and what's going to come out of it. So I think still it's the place to watch. It's exciting to watch. But I think that the grand ideologies, I'm kind of hoping that they don't play much of a role. I'm not sure they will. I think that what we have so far, with the little that I know, and I'm looking forward to reading, I've not read, I've read parts of the articles, I've not read all the cases, but what many South Africans, and I imagine Drucilla, agrees with this in part or disagrees with it, have noticed is that this court, with this amazing mandate, is doing a lot of things just like every other court. And it's interpreting constitutional provisions with prudence, with a kind of care, with an eye on their own legitimacy. Where they have a substantive right, they don't take it. They go for the procedural right. They go for reasonable engagements of different kinds and not for a substantive definition of what a right is that has to be met by a government. They're being careful, maybe being too careful, maybe being even more careful now because the Laurie Ackermans are no longer there. The Albie Sachses are no longer there. The generation that had that kind of hero credibility is no longer there. It's even a different court in terms of where it's going. And so I guess all of this for me is part of my caution and my kind of questioning for Drucilla in those terms. I'm not, I share your least favorite person in the world. I probably share in terms of values of where you would see things going, and yet I'm profoundly uncomfortable with your characterization if that means that that's how the Constitution is supposed to be implemented.
Should we take some questions, or do you want to?
Well, I'd like to maybe just, that was a lot. First, Roger, too. Justice Ackerman has read The Human Condition. He's a big reader. And he wasn't part of the negotiations in the armed struggle. We'll come to Albie in a minute, because one of the books that's not in our series is a book that I did with Albie called Albie Sachs and Transformation in South Africa, where there's a whole 5-page exchange between Albie and myself about what happened in Mozambique. So he faces that in this exchange. It's a long essay by me, Comrade Judge, Can a Revolutionary Become Justice, an essay by Karen Van Marl on the jurisprudence of generosity, prefaced by Albie, introduction by me, and then the exchange.
This is out already, or do you say this is coming?
It's supposedly out and being mailed to me as we speak. So it's actually a book with Albie Sachs on all of these points. So I would encourage you to read it. And the exchange, as oftentimes happens when it's and it went on for 2 days, led to a real confrontation on these points. But first let's do Bernstein and privacy. Because Ackerman had read Anna Arendt, he wanted to develop a nuanced jurisprudence in Bernstein to help have a kind of prudence and sophistication of what dignity might mean. And so what he came up with is that privacy gets attenuated the more and more of the activity is public. So for a certain point in time, like say you're an accountant for a big company and you say, well, the privacy protects your record, then in Bernstein they say because it was about such a case, no, the accountant is a public certified accountant and that it's more important that the public know what the charge of corruption is. But in certain things like flying bridge, well, at a certain point you have to say that could be very important to the person or less important to the person. And so the more you get, then when you go one step back and you go into marital relations or sexual relations, it's also the way privacy plays out in the sodomy cases, then that's even more private to the person, and you must leave people in their uniqueness. In South Africa, you have polygamy, but you also have philandry. It's the one, again, a society in the world where a bunch of us gals can throw in our lot together and we don't even have to show we're having sex. This also has to do with ancestral wives and the whole complexity of it. So Bernstein was an attempt to actually do, I mean, again, we're talking about phenomenal people. because this is a judge who actually went on her arm and said, yeah, you know what? In these endless debates that we're having about where privacy begins and has to limit, and why it's so hard, we need to have a very sophisticated notion of privacy. And that just, before I turn into Albie in 2 seconds, that takes me to your point. See, I don't think the Constitution committed to the great ideals in any way, given like what I just said about Bernstein, that it's very thought through, doesn't allow it to be sophisticated and prudential in that sense, because all those distinctions that Laurie's making is an attempt to say, hey, if this is really going to work, we have to say a lot more about when our uniqueness really matters, how it matters, and then how we're going to weigh in on it. And that's, you know, what a good judge does. But it still has as the basis that the ideal is dignity. Now, Albie, I couldn't help but smile. But Albie Sachs is also a very dear friend of mine, and I just finished doing a whole book with him, where we spent 6 months discussing the cover, because he did all the art for the Constitutional Court, and what a cover meant for Albie was a big deal. Now, for me, I was like, oh, what about this cover? What about this cover? Okay, let's get over the cover and get the book out. Not Albie. Albie was a revolutionary all his life. He joined the Communist Party. His father was a leader of the Communist Party. His mother was a member of the Communist Party. He grew up a communist. He joined and would have joined the full-out armed struggle, except he hurt his knees and wasn't allowed to participate in it. Saw himself as a revolutionary and committed to the armed struggle for most of his life. Was imprisoned, tortured, imprisoned, tortured, exiled, and then left for Mozambique to help Frelimo develop popular justice. Now, two interesting parts of Albie Sachs's life to play out. The first is the African National Congress, is an organization that in 1977 decided to create an ethical code for the limit of the armed struggle, and Albie Sachs wrote it. He wrote the draft and presented it in Zambia. This is at the heart of the armed struggle. No torture, no imprisonment, no rape, therefore the ends don't justify the means, and that it had to be abided by the indigenous value, Zulu word, of Ubuntu. And there were actually some units that were called Ubuntu units. It was 76 pages. It also regulated smoking, drinking, you know, where you took your shower, how you ate, but also it was absolutely committed to the idea that just because the war is just doesn't mean your means are just. This is how the Truth and Reconciliation Commission got off the ground. This is a little known history about it. The ANC felt obligated to acknowledge that many wrongs were done because I had their ethical code of conduct, and let's face it, it's pretty difficult to live up to in the armed struggle. What's important historically is they had such a code of conduct. Now, when Albie talks about the war in Mozambique, this is a big influence on him because Mozambique did not have that kind of code of conduct. Anything went in the Mozambique war. You had to win the war. And so here, there is anything can't go. And so Albie begins thinking about what went wrong in Mozambique, at least in the exchange, as he begins to think about what the ethical code of conduct has to be on an armed struggle, even if you believe it's inevitable and ultimately just, but then there's the ethical justification. When the idea of the Truth and Reconciliation Commission came out, it began with the ANC needing to make public statements about what they had done wrong in the course of the armed struggle. Okay, it became something much bigger and much grander than that. Also in the course of Mozambique, Albie first favored popular justice but never without a constitution. And he answered a group called the Anti-Bill of Rights by saying there could be a Bill of Rights, but of course would have to be complicated. But there could be a Bill of Rights that wouldn't just be the expropriation of, allow the expropriation or disallow the expropriation of property. 87% of the property of South Africa was taken away in 1913 by an act of the South African Parliament. Now some would say if you steal 87% of the land, you got to give it right back. And that was very much what happened in Mozambique. The other problem with Mozambique, since it was a full-scale war, is landmines are everywhere. So much of the land isn't any good anymore. Much of the industry isn't any good anymore. So the remnants of the war are such, there's literally huge areas of Mozambique that you can't plow, that you can't build on, because nobody knows how to unarm these mines or have an effective way of doing it, or even detecting them all. So in a certain sense, the war was still present. So that leads me to, I'll be reflecting on that and being part of another struggle at the same time, is that you actually see in this exchange how he's worried about a certain kind of popular justice. Of course, now in South Africa, they're worried, Economic Freedom Party, the gold miners, and this is a difficult question. How do you take enough of the land back to actually do justice about it? And of course, the Economic Freedom Party is calling for a return to the dictatorship of the proletariat. I was crossing the border with my work permit, and the border guard said to me, Prof, I need to ask you a question. Do we have to return to the dictatorship of the proletariat? Who won, Lenin or Rosa Luxemburg? That's why I like being there. I cross borders here, and I get harassed for having Ali Shariati books in my bag. Here we're like saying, okay, Rosa or Lenin, let's go. I don't think any of these questions have been adequately answered. I'm unabashedly a socialist. My favorite line from a play is, I may be dead and I may not know who I am, but I'll always be a socialist. So that shows that I may not know what it means to be a socialist either. But I tell these stories, the Bernstein case, because it is Ackerman is a very idealistic judge, in all senses of that word. And yet in Bernstein, he's trying to work out a complex, subtle notion of what that privacy actually is. And I guess to you is like, well, yes, we have to have those worries. I mean, the history of revolution in the 20th century has been a bit of a disaster. We just have to acknowledge that. Mozambique is a horrible disaster. There were other experiments that were less or more disastrous. Tanzania, Ghana, perhaps the Congo would have been different if Lumumba hadn't been assassinated. I mean, because he was a constitutionalist. When you look at that history, you also have to look at the role of the United States, which always puts blood back on my hands, because we were very involved in taking out a number of those leaders who might have gone in a different direction. So I want to not so much disagree with you. I accept a lot of your concerns, I really do. But I think in terms of my message to the young people, the older I get, the more I want to stay on the side of the ideal. I mean, I understand all the problems with it, I really do. But I just feel like when I was a young person, and some of you look so young to me, I believed in ideals, and it gave me the courage and hope to try to fight and change the world, and that gave real meaning to my life, and made me able to accept. I was a union organizer, I was also in Marxist-Leninist groups. I got kicked out of all of them for being a deviationist idealist. Marxism-Leninism didn't like idealists too much either. But I just want to leave the young people with, that really listen to what Peter has to say here about but hang on to it.
Why don't we turn it over to the
Yeah, exactly.
Are there questions?
This is a question about public interest litigation in South Africa as like a strategy. And so I'm really interested in socioeconomic
Could you
rights.
stand at me?
Sure.
Stand up, Socio.
Yeah, it's just easier for me to hear.
Okay. Yeah, so I have a question about socioeconomic rights in South Africa in the Constitution. And so you talked about giving the law back to the citizens and kind of the idea of a substantive constitution that's founded on this idea of dignity. And I was really curious about the seemingly lack of really groundbreaking jurisprudential development around socioeconomic rights. Because as you said, we're seeing a lot of protests. We're seeing like a return to street politics in some sense, and we're seeing like a return to the economic freedom fighters and what that might mean. And to me, that kind of signifies a failure on the part of the Constitutional Court in that jurisprudence. I mean, and there's been a lack, or there's been more of a procedural, to me at least what I see is more of a procedural return as opposed to a substantive ruling on what socioeconomic rights might entail. And that's something that that disheartens me about the court. And I was wondering if you could speak to why you think that might be the case, or even if you think that I'm seeing this correctly and that the return to street protests due to like lack of direct access and a lack of return to specific litigants, what impact that might not have on public interest litigation in the future, and then just that gap between practice and ideal?
Well, it's a very important question, and I think I have a complicated answer, because on the one hand, under Port Elizabeth and the whole line of eviction cases, you see Ubuntu being deployed again and again to turn mediation into a constitutional mandate, which basically, overall, has foreclosed evictions. I mean, what we're talking about in these cases, again, competing rights cases, is when people just go on somebody else's property and take it over and squat. And most of those cases have, because of the mandate for mediation, and that means actual meetings with the people, and the Constitutional Court actually going down and having a sense of what's going on, that evictions don't happen. Now, in the Joe Slovo Township, they did happen. And again, poor Albie, who's being beaten around here, was on the court at that time, said, how do you reconcile using Ubuntu to demand mediation in Port Elizabeth and then order eviction in Joe Slovo? Was that just pragmatic in the sense that they needed to clean things up for the World Cup? Now, Albie would never be somebody who'd want to clean things up for the World Cup, but he thought the conditions were unbearable there and the people were better.
Maybe for cricket, he
Yeah.
was strong.
I know, right? Or just simply clean things up for the World Cup. Certainly everybody wanted to clean things up for the World Cup. And one of the things I've learned is that you can never take soccer lightly. So if I make any soccer jokes, I just get myself in terrible trouble. So in soccer,
Didn't he have some mediation role in cricket? Was it cricket?
Yes.
This is something where
yes, so
he's
it's very Ubuntu and mediation. So the point initially is it's not just proceduralist, it's also substantive. But overall, has it, the dignity, the socio-economic rights been fully developed? Well, I don't think so. And one of the clauses in all of them is to the degree the resources allow. So Saint-Pierre and Blanche and I put forward an argument, including to Albie and other judges, that you should use Ubuntu to say, well, the resources have to be made available. And that clause could be read very, very differently. And that would give some substantive meaning to it.
And I'm sure you've written about that, but that's a position that in international law is increasingly focused on, is the resources available are not necessarily those the state has happened to have collected and laid aside in some way. But I think one of the things Ben is saying is suggesting or asking you the question, is the fact that the protests are in the streets also a comment on the lack of confidence in the courts? Is there a relationship between the lack of jurisprudence and the direction that protest is taking?
I think there's a terrible disconnect between the Constitutional Court and the masses of people. And why I think it's also a complicated question. Particularly if it goes back to popular justice of the dictatorship of the proletariat, which is one step beyond popular justice. That the sense is that things need to be done now, and the dissatisfaction with what the court has done in terms of socioeconomic rights is one of the motivating factors in that, absolutely. What my concern is, frankly, and I've been arguing this against some of my comrades at Birkbeck, I do not think we should go back to the dictatorship of the proletariat. And that, whatever happens in South Africa, I hope that lesson will have been learned, that that's not the way to uphold the ideals of revolutionary transformation. If that goes completely against it, even if it allows for kind of expropriation that seems a quick fix. So I'm with you. The issue of socioeconomic rights is a real problem. They have handouts, and if you ask some of the judges, they'll always say, it's up to Parliament to do it. The people have to do it. And then if the people don't do it adequately or have an adequate enough plan, we send it back to them. But they're the democratic representatives, and we're not. And I think that's an efficient. I thought Saint-Pierre and I gave them a pretty good out with Ubuntu, and so far they have not picked that up. A little bit in Port Elizabeth, because in 2004, Albie said that Ubuntu was not a justiciable principle and couldn't be. In 2005, he used it. So he's a guy who's willing to change his mind. So I'm not saying, even though he's not judge anymore, I'm not saying I've lost the argument yet.
Yes?
I was wondering more generally about, well, I guess the big question, the bridge question that turned I think into a chess question, about the fact that you already have a different opinion than Ackerman on the dignity question. And I think the opportunity, the ability for judges to, the vagueness, the substantive aspect, of course, of the Constitution, but therefore the vagueness, the insecurity of developing law, and especially looking at now today, I think the justices that you have book clubs with are not all of the judges of the current Constitutional Court, and kind of seeing the way in which the court, the cult of the original court that Peter once called it for me, that kind of is maybe transforming into something different. How do you keep the ideal alive in a way when there's so much liberty in how you're going to be interpreting, how you're going to be creating, developing the common law? That's one of your questions.
You know, I am of the opinion that the court hasn't changed as much as other people think. You know, you still have Mosenecki there. I mean, Langan very sadly died last year. Chaskelson died. You have two younger women, black women on the court who are very influenced by Ubuntu. You have Justice Fryman and Justice Cameron who attend all Ubuntu Project events. There's still a very close kind of relationship that the project I run has with the court. And that's something that you just don't see like with the U.S. Supreme Court. So there's certainly people who are very concerned on the court to keep the subtlety, but also the high theoretical commitment that this Constitution demands. So changes, yes, but as sweeping as sometimes they're made out to be, no, because there's a continuity and a crossover and a lot of debate with those justices. And because they have such a different relationship to the academy, I mean, I use the example of Avi saying, no, Ubuntu can't be a justiciable principle. Sorry, Drucilla, won't work. And then in 2005 he said, you know what? We need Ubuntu as a justiciable principle. Because we can't even begin to solve socioeconomic problems without a socioeconomic rights jurisprudence. The debate's ongoing, and that's what I found so amazing. I mean, Constitutional Court justices hang out, they don't have limousines, they go to, my project is very poorly funded, so every rand counts. They hang out and eat, not very great food in the cafeteria, and there's a lot of people on the ground. We have an association with the Rural Women's Association that does a lot of constitutional work and intervention, including in Shulabana, written by Justice Van de Westhuizen, who's not seen as like a revolutionary, maybe the opposite, but gets with the spirit in Shulabana. So, and with the Gay and Lesbian St. Goma Association, which is all about the mobilization of indigenous leaders behind the Constitution. So I think the court's complicated, and we're going to have to see where they go. Do I expect that you'll probably be right, Peter? You're going to see more, you're not going to see probably 23 pages of the groundwork of the metaphysics of morals in the middle of a judgment in the same way that Laurie did. But because Kant's part of the Constitution, you do see these judges. Justice Fryman recently called for a Kant reading group for the justices of the Constitutional Court. And they have to know some Kant, otherwise they're not going to be able to know the Constitution.
One should also just remember that you now have a doctrinal trail of dignity, jurisprudence, and Ubuntu, to a large extent because of Drucilla's work. But it's not just in the Dignity Jurisprudence book. Almost any legal book, case book in South Africa includes a section on dignity jurisprudence now. And so when you go to law school in South Africa, that's what you're taught as part of the Constitution.
But you quoted Dennis Davis in your article, Roger.
Such a cynic about it.
Yeah,
Right, okay, so you've got a very smart cynic.
Yes.
Who's there, and he's consistent with sort of Chris McCrudden, who's wrote a piece years ago, which I hated, but now I think about it. Basically looking at the world of dignity jurisprudence and saying, oh yeah, well there's no coherence to it.
You know what I said to Dennis? Dennis is also, he's a good guy, involved in the Ubuntu Project, but he's coming from the popular justice standpoint. He's coming from the Constitutional Court shouldn't do this much work. Maybe we should give much more space to the popular justice. Yes, he also was in the struggle, not as much as some of these, like the Emeritus Chief Justice, as Sandile Nkobo was one of the leaders of the struggle in Zululand. So as revolutionary force, this is why I call my essay, Comrade Judge, Can a Revolutionary Be a Justice? I mean, it's not an easy question to answer. as the justices are less and less part of the armed struggle, you may have some very good things about that, and you may have some not such great things about that. But I do want to emphasize, like Roger said, the trail of the dignity jurisprudence. And I'm kind of leaving it open to see where the court is going to go in terms of this following what now gets called the Mandela Court, but kind of inaccurately, the Mandela Court. And so, Arthur Chaskerson also tended to be more towards the popular justice front and less for this high-blown theoretical jurisprudence that the Mandela Court supposedly developed. I do just want to say one thing about this court. I edited all these cases, and these people are not short-winded. An assistant of mine once said they traveled with 2 suitcases, one of was closed, and one of the dignity jurisprudence. Sometimes there's like 800-page judgments, and each person writes. And I hated it. If I was in the middle of it, I hated editing this book. As you're going through 800 pages, you're trying to make each judge, in their total divergence, dramatically come through. But it made me proud to be a human being, because they're not cynics. And people change their mind, people are listening, people are thinking, and people are trying to be judges and not just philosophers. And it's incredibly demanding. It really is. It is incredibly demanding. Which is what I always say to Dennis Davis. Just because it's very complicated doesn't mean that it's a Lego building that you can dismantle at any time.
Second.
I was hoping you would maybe talk about those complications. And you might be the wrong person to ask, because you're obviously a dignity jurisprudence proponent. And this might be the wrong room to ask it in, because half of us are human rights students. But I'm more interested in kind of the problems in utilizing the rights paradigm.
The problem of what?
In utilizing, like, the rights. The
Paradigm of rights.
Oh,
right, I mean, philosophical values, like dignity translated into a legal structure, into rights. So, because I'm not as familiar as the 2 students are, but, I'm thinking about compassion being translated into rights, empathy being translated into rights. And so part of, being a human rights student here is we think about what is missing, what we're not capturing. I thought it'd be great to hear you talk about that.
I've spent a lifetime. My first published article was called "Should a Marxist Believe in Rights?" And I left the streets and became an academic, or at least, I never completely left the streets, but because I'm still on the streets all the time. But I don't get paid for being on the streets anymore like I did when I was a union organizer. I recognize in all the arguments in the anti-Bill of Rights campaigns that the very discourse of rights is individualistic, that it leads to my claim against your claim, that we need to have another kind of ethic. And yet, as I became increasingly concerned in my Marxist-Leninist groups about top-down leadership and male domination and the idea of the dictatorship of the proletariat, and that somebody has command over truth, which shows that I am worried about certain kinds of ideologies, very worried, that rights discourse in and of itself is a discourse not just of entitlement, but something like dignity, and maybe we can try to use it through art, and therefore it could be reinterpreted and shouldn't simply be dropped out of the picture, because otherwise what happens is you fall into the models of popular justice, and unless you have small enough units, which is something that Roger mentioned, and where you would really have the exercise of self-governance and sovereignty, which might be an alternative, then you are going to need to retain some kind of notion of the givenness of the individual person, if you want to use an Arendtian phrase, that needs to be spared from the complete gobbling up of your life of politics, but allows you to say, no, I won't do that. Now, because in the name of discipline and all sorts of other collective goods and these various groups I was in, that kind of dignity was completely denied. So you had to take orders. And I think taking orders is not a very political, empowering way of organizing towards the revolution. I'm with Luxembourg and against Lenin on that. The party is only about being with the masses and developing what the masses have to say. But her point of view as rights was, is if we're fighting for the dignity of people, then why wouldn't we have a constitution? So I think it's a very complicated question, and perhaps Roger and I were talking earlier on the radio that people really wanted to go for some kind of notion of popular sovereignty, like in the United States. You'd have to have much smaller units. There's moves to break up the states into much smaller units. I'm not saying it's an impossibility, or the discourse of rights is the only one. But given the failures of movements like Mozambique, and given for all of its economic success, I mean, Cuba has the best healthcare and literacy rate in the world. Fidel went for the dictatorship of the proletariat, not popular sovereignty and not rights. And I don't, wherever we're going to go with this, a more complicated answer to the rights question, I don't want us to go back to saying, rights is just the entitlement of the bourgeoisie.
And it's important to realize that the development of rights that Drucilla is talking about and that we're talking about in substantive jurisprudence, dignity is both a right and an ideal. And as an ideal, it can never be actualized in rights. It's always something that is in the future. Same with popular sovereignty. It's a right, but it's also an ideal. And any kind of substantive discussion, and this is where I think, it can't be an ideology. You have to always worry that these ideals would become an ideology. That they have to be complicated. They have to be thought through. But it's not something to be actualized. It's a substantive ideal that's not supposed to be substantiated in any kind of end form, and that's an important distinction.
And even a way of thinking what you said about the gap between the ideal that you're worried about too, Peter, when people think that it's actualized, is where there's maybe a necessary space for some stronger notion of right, not just rights, but the ideal. And that ideal keeps that gap. If you think it's an ideal and not something to be actualized, then there's always that space. And that space is what I think Albie realized was more and more done in the popular justice of Mozambique.
Other questions? Anyone ask one more?
Unless somebody else has one.
Go for it.
So we're talking about the realization of an ideal in rights. Should I stand here? The realization of an ideal
She's pushing.
in rights. And to me, that might be where one of the disconnects is between the public and the court, is that this ideal of dignity and this ideal of, kind of a more egalitarian society that didn't exist in apartheid. There's a desire for that can't be denied. And coming from the Marxist-Leninist background, to me, I'm curious about how this idea of dignity as an ideal and how people keep trying to realize it through socioeconomic rights, how the transition from RDP to GEAR has affected that in some way. So,
That's the position from my
from the RDP, the redevelopment program, to GEAR, to a more neoliberal capitalist model, has affected that, and then also affected maybe how some of the jurisprudence has been developed. I don't know if it has, but that's something that I wonder is what occurred from that transition.
It clearly affects that famous phrase, in accordance with the resources you have. Because if you organize the economy in such and such a way that resources can't be made available, again, then you're making a judgment about how you judge resources. So I think it's had a big impact on it. And even the housing development's going so slowly, and the reparations program going so slowly. All these have to do with ways in which what you can do economically, and even the right to strike. I mean, the gold miners are on a general strike today because they think that the right to strike is being undermined. Now, their response is to go on strike. And they're not just striking gold miners anymore, everybody's joining with them. So I think that there's a real tension that has to be recognized between a drive for economic justice now and making more resources available so you can develop a real effective socio-economic jurisprudence. The schools are a big mess in South Africa, huge mess. Still, and that's not good for the country at all. Even though the ANC pours money into the schools, it's very ineffective. So I think that that's where we are at this moment. And one of the deep and serious questions is, can you have a substantive revolution? And I'm not a big fan of Julius Malema, who I do see as an AR. But he has gained popularity because he says, what we're going to do? We're going to take the ANC Freedom Charter, we're going to expropriate the expropriators, and to hell with socioeconomic rights. It gets back to the question of the young man earlier. We're not going to have socioeconomic rights. We're going to get 87% of the land back and put those white people out in the middle of nowhere. But they can have a tiny section of the United States, and that's all they can have.
Can I ask a follow-up-ish question, Roger?
Yeah,
Okay.
please.
So something to me sort of, I guess maybe it's not a follow-up, maybe it's a different question. I promise it's related. Which is that in that great moment, the great moment from '94 to '96, it was a long moment of everything coming together. It reminded me, because Ben mentions the RDP, and I would have thought, if you had said what were the pieces of the transformation that everybody believed in at that moment, it would be the Constitution, the Constitutional Court, and the RDP. And I remember again Albie Sachs at a moment in a talk, pausing in the middle of the talk and saying, 6% growth, 6% growth. I don't know what we even are going to do if we don't have 6% annual growth. They were so connected in everybody's mind. But then there were other pieces that were connected as well, which it seems have fallen away. And the Constitutional Court, in some way, you're confident about it, and that's reassuring, actually, to me. But cautiously optimistic. But in 1996, we were optimistic because there were other institutional mechanisms intended to be put in place. And one of the other potentially brilliant, innovative mechanisms was the Human Rights Commission. And it had a beautiful piece of mandate which was in economic and social rights that was modeled on the international covenant. And it was going to play a role there. Within a matter of a year, it had uselessly eaten itself up over various things. And you have the ombudsman, the public protector, and now you have the other committees and commissions. And I don't know, it's as if we're back to, when I say that, the court starts doing what every other court does, it's like the government is just doing what every other government does. That these other innovative mechanisms that were set up to build out something more in the way of state structures to ensure the Women's Commission, that were set up. What do you think? Are those as depressing as it seems?
Well, it's depressing. Because, that's part of also, COSATU and the Communist Party are supposed to be part of the government. A major union organization is supposed to be part of the government. And they also, even COSATU, the gold miners broke away from COSATU, felt very excluded. And the idea was that there would be all sorts of intermediary institutions, and these intermediary institutions would be extremely important in keeping the disconnect from happening and developing a very solid socio-economic right. And, at one point, Sampi and I went to the Human Rights Commission, which still exists, and said, what about our idea? Let's use Ubuntu and go this way, and let's write a white paper, and let's try to get it to the attention of all the justices. And I think that idea in South Africa of having many strong intermediary, it's not exactly civil society because it's somewhat different, was a way of thinking about getting people participating in the new dispensation. And they have been very disempowered, and even more so under Zuma. Zuma's no popular justice man. He really is not. And he's also not, he's more of a party man. He's the ANC is going to rule until the second coming of Christ. That's Zuma. That's a different kind of statement than the ANC will continue to be the party in power because it embodies the ideals. So he's a cynic. And, that doesn't mean that he wasn't at one time, a serious revolutionary. And it gets back to the ideal. Zuma is about ruling and staying in power, and he's really dismantled a lot of these commissions and disempowered them. He really hates the Women's Commission. He really hates it because they called him a rapist, and he didn't want to be called a rapist. So I see that as really worrisome because we have a lot of things, and in South Africa, I obviously identify myself as South Africa. There's spending limits, you can all be on television, and not everybody wants to be in Parliament, and all these intermediary groups, including like the traveling provincial commissions that go out with the laws of the provinces to all the people, these have all been really undercut by Zuma. And I think it is a concern because then it gets back to, okay, none of this is working, let's throw it all out. Dictatorship of the proletariat, expropriate the expropriators, which is what Malema says. And then, after that's done, we'll worry about all this constitutional court stuff. And maybe we won't have a constitutional court.
Time for one last question if there's someone. Students can be on anything. You don't have to be an expert in South Africa. Yes, Jack.
I'm wondering, so if you're looking at dignity and looking at perhaps people's ability to have a place in the compromise of the Constitution, kind of looking at the Constitution as a collective compromise, as Rosen painted it, do you think that this emphasis that's put, or having people who are part of the government who are very idealistic and are sort of holding idealistic roles and having Kant study groups, do you think this emphasis on ideals would infringe on people's ability to compromise? Because ideals, even if they're not implemented, are still absolutist in their nature and therefore can't be compromised, and could affect on a collective ability for everyone to have their own say, because you're talking about ideals that are being defined by that selected few at the top, who are going to these study sessions and defining this as to what they mean, that could prevent other people's ability to compromise and have a way and say in what their constitution is meant to be.
But, when you think of an ideal as a regulative ideal, you are always remembering that it's incomplete and can't be actualized.
You might want to explain what a regulative is.
The regulative ideal is something that literally is there as a horizon. It can be thought, but it can't be known. This is very Kantian because it's not part of the phenomenal world. So you can think it, and when you think it, it always is configured, and it's configured and represented. I mean, a famous example is the veil of ignorance. I mean, what did Rawls want us to do? It's an experiment of the imagination. So if the ideals are only being filled in, both individually and politically, and ethically, in all sorts of social settings, including these commissions. These commissions had as one of their mandates figuring out the nuances of those ideals in a very complicated society. And that's why they were so important. It wasn't that the ideals, and why I mentioned Bernstein, were just going to be these abstract configurations. They were going to be given a lot of nuance. And this is, in fact, something that's happened with Ubuntu as a justiciable principle. So I think that in an odd way, when Albie says, and again, I think you guys will enjoy this exchange because Albie you kept pestering, I got him locked in a room. And he had nowhere to go. We were gonna get to the Mozambique question out of the
So you also had trouble getting to that point? I really did not want to talk about it.
He does not want to talk about it.
Okay, good. That's good. Actually.
Definitely, but he does. And what he's sort of saying is that as he realized that the war couldn't be won, that there was going to be negotiations. And Chris Hani said no negotiation, go straight to a constitutional assembly, so that even negotiations was hugely problematic. He was a member of the ANC who left to join the Communist Party, an armed struggle person, and was assassinated. So I think that ideals are not necessarily against compromise, because if you know they're incomplete, then you're configuring the ideal, and you may configure differently. I just said Justice Ackerman and I have been arguing about this bridge club example for 10 years. The real answer is that it's very hard to define it, precisely because the ideal could be cut in different ways. So he had to develop then the whole notion of privacy to go with it. At the end of the day, I think at this point, I've been convinced by Roger that neutrality and givenness are probably the best ways to think about dignity as the basis of that jurisprudence, much better than reason. And that, I think, is what started to happen, not because everybody went on, but because they saw the need for a nuanced jurisprudence, and neutrality and givenness helped more in those competing rights situations. But I actually think sometimes idealists are seen as non-compromising. I think the dangerous people in the Marxist-Leninist movement are the people who say that they're dimads, dialectical materialists, and they know the truth. And therefore, what the party says is the truth, and therefore it's absolutely unchallengeable. An idealist never have truth.
A true idealist always remembers the finitude of the
Absolutely.
humanity that can't know
Absolutely.
the ideals, and this holds it open. The ideological idealists are the ones we worry about. I think Drucilla's made
And the
that.
dilemma is one, and he's getting a lot of attention, and we're coming up to the election.
And by the way, the first person who ever taught me that was Drucilla. She has her first book, right? Her second book,
Philosophy.
with the Philosophy of the Limit, was the book that made me contact Jared Nash to come and work with her, which is about the limit in the ideal, right? That was the book that, so long ago I won't say, first made me come and think and see the importance of this kind of thinking.
And that was written in many ways as a response to me in reflecting on the problem in Marxist-Leninist groups of not seeing the limit. And that's the older Alvey. Alvey sees the limit a lot more clearly now than he did in Mozambique.
Please join me in thanking Professor Drucilla.